Good evening, gentlemen. I'm sure our day was quite peaceful and awesome. You're welcome to tonight's online session. I'm still your host, O.O. Stevens. And tonight we are going to be looking at closing address and judgment in civil litigation. Closing address and judgment in civil litigation. But first of all, let us take what a closing address is. This is the final stage of a trial where a party canvasses or argues issues raised on evidence adduced and the applicable laws in favor of his theory of the case. Now, closing address is just like the marriage of facts and law in order to convince the court to grant or refuse to grant the claims or prayers. So what happens at closing address is all the evidence that you have thus adduced in the course of trial. It is at the closing address that you're going to now marry those evidence or marry those facts, blend them with the position of the extant laws, now trying to prevail on the court to give judgment in your favor. And the general rule is that the last person to call evidence, the last party to call evidence commences the address, and thereafter the opposite side has a right of general reply. So the last person or the last party to call evidence is the person that is expected to file his closing address first. Now, if you notice now, in the course of our discourse with respect to this closing address, we are going to be using first party to commence second, last party. So the reason why it's like that is because there are some instances whereby the state of pleadings or whereby the nature of the pleadings that have been filed by the parties can maybe place the general burden of proof on the defendant. So that is why the rules of court specifically were making use of the word party, the party to call, the first party to start, the first party to commence. They are not saying the claimant and they are not saying the defendant. So it is dependent on the nature of the matter that is before the court that will now know who will be the first person to open his case and the last to call evidence. So that is why the language is being used in that manner. So note that the rules of the court did not make use of the words plaintiff or claimant. Sorry, plaintiff, claimant, or defendant. It only uses the word party. Now, let us now look at explicitly the language of the rules by the position of Order 32, Rule 14 of Order 32, Rule 14, Rule 15, Rule 16, and Rule 17 of the Abuja High Court Rules. So let us look at what it specifically says. Now, one, if after the party that opened his case first closes his case and the other party did not call evidence, then the party beginning would within 21 days file a written reply. File a written address. What this is to this effect is if the party that commences or if the party that opens his case first, it can be the claimant, it can be the defendant. So if after that party is done opening and closing his case, please, closing case is different from closing address. Closing your case is where you people are no longer canvassing any arguments or adducing any evidence. Then closing address is the stage now whereby you are now filing a document called final written address or closing address, where you are now going to now try to be urging the court to give judgment in your favor by trying to expose to the knowledge of the court the laws that are in support of the evidence that you have thus canvassed or adduced. So what we are saying now is if the party that first opened and closes his case and the other party did not call evidence, then that particular party that opened his case first will now be the one that will file a written address, and he has within 21 days to do that. You can see Order 32, Rule 14 of Abuja High Court Rules. Also, the next, where the other party calls evidence, then such party shall within 21 days after the close of evidence file and serve his written address. So if particular party opens his case and the other party now also called evidence, then it will be that party that came later, the party that didn't open, the party that opened his case after the first party had opened his case. It will be that party that will now file his written address because he adduced evidence. That is why we said earlier that the last party to call evidence will be the first person that will file a written address. Now, where the party has been served, that is any of the parties. Now remember now from what we discussed now in the above two scenarios now, if the party that is commencing the matter commences and closes, and the other party did not call evidence, then that party that commenced the matter will file his written address first. Order 32 Rule 14 of Abuja High Court Rules. Now, the next situation, by virtue of Order 32 Rule 15, says that if the other party, that the other party now is the party who opened his case and closed after the first person had opened and closed. So if that other party called evidence, then it will be that other party now that will now file his written address first before the person that commenced his case first. That is the implication of the two scenarios. Now, where the party has been served, so now where either of the parties have been served now, so no matter the person that filed written address first, now the other party is definitely going to be served. So where the party has been served, he shall within 21 days file his own written address. That is Order 32 Rule 16 of Abuja High Court Rules. And the party that first filed his written address shall have a right of reply on points of law only, and he shall file his reply within 7 days after he has received notice of the other party's written address. So summarily, the time for filing written address is 21-21-7. Because if I now serve you a written address, you are expected to also file your own, and I have within 21 days after the close of the case to file my written address. Then you, upon having been served, you also have within 21 days to also file your own written address. Now, I, who is the first person now that served the written address, now has what we call a right of reply, but the reply should only be on points of law. So if it is with respect to new facts that have been raised in the written address of the other party, then you ought not to file any reply. But if it is with respect to the position of the law, which is probably misrepresented or misapplied by the other party, then you can actually have a right of reply. That is what we mean by on points of law. And it is worthy of note that counsel is expected to come to court on the date fixed for adoption of final written address on the day fixed for adoption of final written address as their argument in the case. Now, after the adoption by Order 33 Rule 2 of Abuja and Order 33 Rule 4 of Abuja High Court Rules and Order 35 Rule 4 of Lagos High Court Rules, then please note that these rules we are using the new rules. We are using the 2019 Lagos Rules and the 2018 Abuja Rules. So oral arguments, that is adumbration of key points of not more than 20 minutes, shall be allowed for each party respectively. So what we are saying now is, on the date that has been fixed for the parties to come and adopt, because after they have filed their written address, a particular date will be fixed for them to just come and adopt their written address, that it is going to be their oral argument in the matter. So when they come to do that, the court may now allow them to adumbrate. Adumbrate means let them just say something orally that will maybe beautify the contents of the written address that they have already filed. That is what we call adumbration, and they are entitled to 20 minutes each to so do by Order 33 Rule 4 of Abuja High Court Rules and Order 35 Rule 4 of Lagos High Court Rules. Now let us look at the contents of a written address. I've said it before when I release a voice note on the tips to drafting in civil. I talked to you that most often than not, when you see any question with respect to draft a written address, you are just expected to just draft the heading of the court, draft the suit number, draft the name of the parties, and give the heading of the document. That is where you are going to write final written address. Then other things, just outline it. So the content of a written address are: you have heading of the court, you have suit number, you have parties to the suit, you have heading of the document, you have introduction, you have summary of facts, you have issues for determination, you have conclusion, you have list of authorities, you have dates, you have name and signature of counsel that prepared the written address, and you have address for service. So those are the contents of a written address. All right, let us look at judgment. This refers to a reasoned decision of the court which is delivered at the end of a trial after hearing the parties. So one thing that you need to note about judgment is that it comes after the parties might have filed their written address. So once the parties have filed their written address and have finally adopted the written address, then the court will now give its judgment. So now the general principles guiding judgment are that the judgment of the court shall be in writing. The court has no power to deliver oral judgment for it to be reduced into writing later on. So it must be in writing. However, the magistrate court in the south can deliver partly written judgment and the rest can be oral. Also, another principle that guides judgment is that consent judgment may be entered but has to be exactly agreed by the parties. When we talk about consent judgments are the parties may now agree to their terms of settlement. Then they will now bring the terms of settlement for the court to endorse on it and make it binding on them. So that is what we call consent judgment. So consent judgment is just that the parties have already agreed. So they now bring the terms of the agreement before the court for the court to actually look into. And once a trial judge delivers his judgment, he becomes functus officio. That is, he ceases to hear the matter again or reopen it for any reason whatsoever, except in the following circumstances. 1. To correct clerical errors or mistakes. 2. To set aside a default judgment. 3. To set aside a judgment obtained by fraud. So these are the type of instances or circumstances whereby the court may be allowed to reopen a judgment that it had already given, maybe to either vacate it or to vary it. A court cannot either directly or indirectly set aside the previous judgment or order made by a court of competent or concurrent jurisdiction. Only the court that gave the judgment can have the jurisdiction to set it aside. What we are talking about here is that, assuming the judge in High Court 1 gave a judgment, then what we are talking about now is that it is going to be that same judge that can set aside the judgment for fraud. Now, where a judge made an order which is a nullity, the judge or another judge of coordinate jurisdiction can set it aside. So there are two different things now. Assuming now that what the court did was to make an order and the order itself is a nullity. Nullity means that maybe it doesn't have jurisdiction ab initio to entertain such matter. So any order that it makes on that particular matter is in itself null and void. So what we're saying now is that that particular court that made that order may set it aside, or another court of coordinate jurisdiction may set it aside. So the implication now is that, for instance, now the High Court of Kano State can set aside such a judgment, probably if it is given in High Court of Kaduna State, because they are courts of coordinate jurisdiction. Or we can even say that the judge of High Court 1 in Kano State High Court can set aside any order that is made which is ab initio a nullity that was made by the judge of High Court 2. But assuming that the judgment of that particular court, judge of High Court 1, was actually obtained by fraud, then ordinarily the judgment itself is not a nullity. So it is only that particular judge of High Court 1 that made that particular judgment that was obtained by fraud that can set it aside. So another judge, even if the judges of coordinate jurisdiction cannot set aside. So the only time a judge can set aside or a court can set aside the order made by another court of coordinate jurisdiction is if that order is in itself void ab initio. So you need to appreciate those differences. Now, a court has inherent jurisdiction to vary its order so as to carry its own meaning, or in cases where the language used was doubtful, in order to clarify the position or an error. So, however, this does not entitle the court to give a different effect to the order. What we're talking about now is that there could be instances whereby a court may make an order, and maybe if the court gets other facts that were not maybe available to the court at the time of making the order, the court can revoke that order, or the court can vary the order. That is what we are talking about now. And every court shall deliver its judgment not later than 90 days after conclusion of evidence and final address. But however, a judgment is not a nullity for the simple reason that it is not given after the expiration of 90 days from the conclusion of final address, unless it has occasioned a substantial miscarriage of justice. So you may choose to look at section 294, sub 5 of the Constitution. Now let us quickly look at the material distinction or differences between a final and interlocutory decision of court. We have final decision and we have interlocutory decision. Now, it has been the argument in the case of ex parte mor ex parte more, as in the way you spell ex parte, motion ex parte, the way you spell ex parte, then you will now write M-O-O-R-E, M-O-O-R-E. A test was laid down to the effect that when a decision is given and there is no cause for the parties to go back to the same court that gave the decision, then it is a final decision. But if the parties shall have to continue with their case before the same court that gave the decision, then such decision is an interlocutory decision. So it is in this respect that the court will have held that when a judge decides that he has jurisdiction over a case, then such is a final judgment. Now, what are we talking about here? I hope you know that when we talk about interlocutory decision of the court, the implication is that the court gave an order over a matter that is still before it. So meaning even after the order is given, the matter is still going on before that same court. So the court is not functus officio with respect to interlocutory order or interlocutory decision made by it, but the court is functus officio with respect to final decision made by it. So for instance, now if I am maybe trying to argue title of land with my elder brother, and we decided to approach the court for the court to now determine who has title to the land. And when the matter was ongoing in court, my brother was already building on the land. And even as we're in court, there is a work going on in that land every day. So I can bring an application to the court, asking the court to ask my brother to stop building on that land, pending when the court will determine who has title to the land. So if the court decided to tell my brother, stop building on that land until this matter is determined, that is called interlocutory order. So my brother has been asked to stop, but the matter is still going on in court for the court to determine who owns that particular land. But assuming the court finally now gives decision as to title, say maybe it is me that has title to the land or it's my brother, that is called final decision. So remember now that we are saying now that the difference between interlocutory decision and final decision is that if there is still a need for that matter to still be going on in that particular court, then it is interlocutory. But if the matter is no longer ongoing in that particular court, then it is not interlocutory, it is final. That is why it has been stated clearly that assuming maybe you raise an objection, a preliminary objection, saying that the court does not have jurisdiction. If the court looks at your objection and the court says that it has jurisdiction to try that matter, so since that matter is still going to happen since that matter is still going to go on in that court, because the court has already said it has jurisdiction, such has been stated to be an interlocutory decision. But assuming if the court finally looks at your objection and the court says, yes, you are correct, I don't have jurisdiction, that unavoidably means that you people are going to another court to try the matter. So that in itself will be seen as a final decision of the court, because the court does not have jurisdiction, so the matter will not be ongoing before that court. So that is the implication of an interlocutory and final decision of a court. All right, let us look at types of judgment. We have various types of judgment, and we're going to just be briefly discussing them. We have consent judgment. I believe by now you already know that consent judgment is a type that the parties have already consented to. So the parties have decided to sit and have an agreement, and they also have what we call terms of settlement. And most often than not in practice, they are expected to reduce these terms of settlement in writing and present it to the court, and the court will now pronounce on those terms of settlement as binding, and such judgment will now be enforced as though it is the judgment of the court. That is what we mean by consent judgment. And it occurs where the parties agree. So the parties must agree before there will have to be a consent judgment. Now we have summary judgment. Summary judgment, I believe by now you people already know. We have treated it, and I'm sure that you have listened to the voice note. Even if you have not, just listen to my voice note on summary and default judgment. This is a type of judgment that is given when the claimant can be able to establish for the court that the defendant has no good defense to his claim. So once you can establish that the defendant has no good defense to his claim, then the court can give judgment. The court can grant you what is known as summary judgment. But you need to note that there are procedures for it. So the voice note on summary judgment will expose you to the procedure, because you don't just come to court and tell the court that this man does not have good defense and the court will just give you judgment like that. It doesn't happen that way. All right, we have default judgment. Default judgment. Now you also need to note that summary judgment cannot be set aside by the court that gave it. It can only be set aside on appeal. Now, but for default judgment, although default judgment is the final decision of the court, but the court that gave it can set it aside. And this is a type of judgment that is given either in default of appearance, that is, the party did not file his memorandum of appearance, or default of pleadings, he did not file his statement of defense. So that is default judgment. Now we have declaratory judgment. When we talk about declaratory judgment, this is a type of judgment that does not require the parties to do anything. There is no obligation on any of the parties. So it just declares the rights of parties and stop there. For instance, now, I hope that most of us are aware of when the Chief Justice of Nigeria, Onogen, was removed, and the House of Senate were actually approaching the court to help explain or to help interpret the position of Section 292 of the Constitution that says that where the Chief Justice of Nigeria is to be removed, then the complaint shall actually be investigated by the House of Senate, and the House of Senate by 2/3 majority can recommend for his removal. But such was not what happened in the case of Onogen. It was the CCT, Code of Conduct Tribunal, that recommended the removal of the Chief Justice of Nigeria then. So the House of Senate now approached the Supreme Court, asking the Supreme Court now to interpret the position of Section 292. So assuming the Supreme Court finally interprets and said that Section 290 is to the effect that it is the House of Senate that has the power to recommend the removal of the CJN, the court just said it and stopped there. The court did not tell Buhari, go and revoke the suspension. The court did not tell the House of Senate, go and carry out your function. The court only declares that this is the position of the law. So it does not give obligation on any party to do anything. So nobody is a judgment debtor here per se. But because of that declaration that has been made by the court, then the House of Senate can now decide to carry out their powers if they want. If they want. So they can decide to carry out their functions if they want. So such is a declaratory judgment. It only declares rights of the parties. It does not place an obligation for somebody to carry out any function, for somebody to pay anything. That is it. Now we now have executory judgment. Executory judgment is a direct opposite of declaratory judgment. Executory judgment is the effect that an obligation has been placed on somebody to perform an act. For instance, now, if the court gives judgment and say that you should go and pay this someone the sum of this, there is an obligation on you. There is an obligation. Such is called an executory judgment. It's a type of judgment that can be executed. It's a type of judgment that can be executed against the other party who is known as a judgment debtor, and you who judgment was given in your favor is known as a judgment creditor. Or we have interlocutory judgment. This is the judgment given during the pendency of the suit. We have talked about it when the matter is still ongoing in court, and maybe for the purpose of justice. So the court gave the court gave an order requiring somebody to do something or not to do something pending the determination of the substantive suit that is before that same court. Such is known as interlocutory judgment. While final judgment is the effect that the court has already given judgment and the court cannot visit the judgment again, and the matter is no longer pending before that same court. So the court has determined it and it has left the hand of the court. So revisiting the matter can only be on appeal, or where it is obtained by fraud, or where there are clerical errors, then the court can reopen it like we have noted above. Alright, we have a concept known as dismissal of action. Dismissal of action. For instance, where a claimant or a counter-claimant fails to prove his case to the satisfaction of the court, then the claim or the counter-claim will be dismissed. A dismissal is a final judgment of a court and can only be challenged on appeal. So dismissal means that the action has been heard on its merits. So this is different from striking out. I believe that most of us have actually had striking out and dismissal. What's the difference? So in striking out, if the court strike out a matter, you can relist that matter in that same court, meaning you can still bring the matter back in that same court, because striking out was not actually heard. The matter was not actually heard on its merit before it was struck out. Before it was struck out. Now we have another concept known as non-suit. Non-suit, N-O-N, you put hyphen, S-U-I-T, non-suit. An order of non-suit will be made by the court where the claimant has not totally failed to prove his case, but he has, however, not led sufficient evidence to entitle him to judgment, as the defendant is not entitled under that condition also to judgment in his favor. So what we are talking about is, for instance, now a matter is ongoing in court, then the claimant has not been able to prove that case to the satisfaction of the court. However, the court did not actually consider it justifiable to dismiss the matter, because the claimant has probably led an evidence, though that the evidence is not to the satisfaction of the court, and also the defendant will not be entitled to have the matter dismissed. So this is where the court will grant us. So this is the effect now, that the court will give the claimant the opportunity to go back, prepare, and release the matter. So when the court gives an order of non-suit, it is the effect now that the claimant will be given another opportunity. Please go back, look at your documents again very well, prepare for it again, and come back to this court and refile it. The reason is because the court does not consider the matter worthy of being dismissed, because the claimant has proved something. However, what he has proved has not actually convinced the court to give judgment in his favor. And also, the defendant will not also be entitled to have the matter dismissed. So that is when the court will now grant what is known as order of non-suit. But one thing very paramount is that no court has an inherent power to grant non-suit. So there is no court that has a power in itself to grant a non-suit. So before a court can actually exercise the power of granting non-suit, the rules of that particular court must empower the court to so do. The rules of that particular court must empower that court to so do. So in other words, the court cannot make such order if not expressly empowered by any statute or by the rules of the court. I believe you have heard, when you are drafting your motion, where you see and under the inherent jurisdiction of this court. Now what we are talking about now is with respect to the order of non-suit to be granted by the court. There is no inherent jurisdiction to that effect. So there must be expressly a law or the rules of that particular court empowering that court to be able to grant an order of non-suit. It is not inherent. It is not inherent. Now let us look at delivery of judgment. Delivery of judgment. A judgment generally is to be delivered in an open court unless the court otherwise directs. In other words, there are exceptions to the principle of delivering judgment of the court in the open. And those exceptions are where it is with respect to public safety, where it concerns public order, where it has to do with public morality, then judgments may not necessarily be delivered in the open. And a judgment may be written by one judge and delivered by another judge, provided that the person who wrote the judgment is the person who had the case. So a judge can actually write his judgment, then probably one or two things made him not to be available. Another judge can deliver that judgment. But what we're talking about now is that it must be seen and it must be shown that the person who wrote the judgment was a person that had the case from the beginning to the end. And once a judge has left that court, he cannot deliver judgment in that court again, except it's on a matter he had before leaving the court. So once you have left this particular court, you cannot deliver judgment again in this particular court. So the judgment you'll be delivering will be with respect to the court you are now in. But what we're saying now is that, assuming you have had the matter in a particular court and you have not delivered judgment with respect to that matter, you can still be allowed to come back to that same court. Even if you have been transferred to another court, you can still come back to that same court and make delivery of the judgment that with respect to the case that you had while you were still in the court. And all the justices who had an appeal must not all be present at the time of delivery of the judgment. Now, where one justice is absent, his opinion can be read by another justice of the court. So what we're talking about now is that, for instance, now at the court of appeal, or a matter that was heard on appeal, you know very well now that matters will be heard on appeal. If it's at the stage of court of appeal, it must be 3 justices at least, and if it's at the Supreme Court, it must be 5 justices at least. So what we're talking about now is all the people that had that particular appeal must not necessarily be present when judgment is to be delivered. In other words, assuming even 1 or 2 are not present, one judge can deliver the judgment and he will now pronounce the judgment of other justices that were not present, and it will still in itself be valid. Now, court is to furnish the parties with the duly authenticated copies. The duly authenticated copies of the decision within 7 days from the date of delivery. So a party is entitled to the certified true copy of the judgment of the court within 7 days from the date of delivery. Now, however, non-compliance with the provisions of giving the copies of the judgment within 7 days, non-compliance with that does not render the decision invalid. It does not render the decision invalid so long as there was no miscarriage of justice that was carried out. But most often than not, it is necessary to have the party getting the certified true copy, because it may have to help him to prepare for his appeal, assuming he's a type of person that is not satisfied with the judgment of the court and would want to appeal further. And where a judge writes his judgment but dies, retires, or is elevated, or however not a member of the court again, his judgment can only be pronounced. When we talk about pronouncement of judgment, it is the effect that you can just say that my brother justice says or holds that you are guilty. You're not going now to go and read the ratio. You're not going to go and read the issues that have been raised by your brother justice. You're not going to go and talk about the facts of each issue and also the law that are, or the legal arguments of each issue. No, you just pronounce. Pronouncing the judgment means just tell us what this man at the end of the day decided to hold. Did he hold him? Sorry, you don't use the word guilty in civil. I'm sorry. So did he hold him liable or not? So that is pronouncement of judgment. That is when we say that judgment has been pronounced, and the judgment must be signed by the judge that wrote it. Failure to sign a judgment renders it invalid. Failure to sign a judgment renders such a judgment invalid. And note that by section 285 sub 8 of the Constitution, and by section 9 of the Second Alteration Act 2010 now permits courts in all final appeals arising from an election tribunal or court to adopt the practice of first delivering judgment orally and giving reasons thereof later. Let me explain this. For instance, in an election matter now, if a matter is now on appeal, probably at the Supreme Court, and we know that the Supreme Court is the court of the final arbiter. So meaning that there is no other court that you can appeal again against the judgment of the Supreme Court. So the Supreme Court has been empowered by the case of Goni versus AMPP. That the Supreme Court can choose to come, because election matters, they are always sui generis and time is of the essence. So the Supreme Court can come and say that the winner of the election is A, B, C, even without giving reason why it says that. And that Supreme Court can now give reason at a later date. That is what we're talking about. So instead of time to catch the court can give such a judgment. That is, and reserve the reason for the judgment at a later date. But remember, such a court must be the final court. Assuming there will still be a need to appeal against that judgment, then you cannot do that. You can only do that when the court is the final court. So that is the implication. And on that, we are going to be validly drawing the curtain on this topic. And I wish you all quite a blissful and awesome night rest. Good night.